Sir, just
Sir, your mic is mute. I think so. You're saying anything?
sir. Hello, hello, sir.
Yeah, Rama,
Hello.
చెప్పండి.
Start कीजिए ना. Start. Actually, your voice is not audible.
I'm audible?
Yes, sir. Yes, sir. You are audible, sir. You can start the session, sir.
Okay, thank you. Thank you very much. Thank you, CMR group of institution to call me this type of webinar on the topic Indian patent law and international patent. I'm also thankful to Mr. Raman Mandal for inviting me in such kind of webinar to directly benefit to our institutional students, students of UG, students of PG, because patent is one of the part of our society, because we everything we can our property means intellectual property right granted by the government of a nation, any nation, whether it is India, whether it is US, whether it is China, to an inventor, that gives him or her exclusive right to the invention for up to 20 years, in exchange for disclosing the details of the new technology to society for its ultimate benefit. Right now we can start a little introduction to IP and IPR, because after going forward in the patent law, Indian or international, and the difference between them, some little introduction about the intellectual property. It is the property created by the person or person using his or her intellect for ultimate use in commerce, and which is not available in the public domain. Basically, the examples of an IP, basically it is an invention related to a product or a process. Basically, what I'm now repeating this term, it is invention related to a product or a process, a new design also of an article, a literary or an artistic work, and a trademark. Trademark, it's a word also, a symbol also, or a logo also. Because in this intellectual property, we can define our right and which is given by any nation. That is the main representative, means government, to the applicant, right? Now, it is an asset, can be exploited by the owner on commercial gains. Why should an IP be protected? Why we need a rules, regulation, or law for this IP? Because IP is an asset and can be exploited by the owner or the commercial gains, right? IP owner can stop others from manufacturing and selling products and service which are duly protected by the IP owner. IP owner can sell or license the IP for the commercial gain. One of the best example in invention and innovation, because we talking in any engineering college, any social activities, or any intellectual person between them, that what is the difference between innovation and invention? Invention, there is this I quote with example that you can see a pencil, right? Pencil, it is a innovation, right? Or invention. Innovation or invention? It is a invention. It is a invention. Also, a eraser, which can we erase to writing any words or through pencil. This is also a invention. But pencil is different thing, eraser is different thing. When we combine both of them, when we combine both of them, means pencil top of her point, a small little eraser, we can fix it, and we sell them or something, we buy any from shopkeeper. This is the innovation, because we can utilize already invention product through a pencil or a eraser. We combine both of them and we create a new product. We develop a new product. These are the this is the main difference between the invention and innovation. We can protect them through IP, that the laws, rules, and regulations. Because in IP already we discussed, there's the different type of things: patent, copyright, trademarks, trade secrets. These all design patent are also all are coming in this IP. Okay, IP can be used to establish the goodwill and a brand value in the market. Inventor, creator, or author or an IP can mention about the IP in his or her resumes that does now their complete, right? IPR certificate establishes a legal and valid ownership about an intellectual property. Or these certificates through follow through some laws, some regulations, some forms. Somehow we can pay to publish them, right? Some legislative framework of IT administration, because IP and this related IPR, the Patent Act comes at 1970, right? 1970, and before after in 2005, as amended the patent rules and their laws. Also only patent, because patent, design, trademark, geographical indications, right? The copyrights are comes under the umbrella of IPR, intellectual property right, right? Then the Patent Act comes on 1970 and amended in 2005. The patent rules and regulation amended in 2006, right? Design Patent Act on the year of 2000. The design rule amended in 2008. The Trademark Act 1999 and the rules are comes in 2002. Geographical indication of goods means in this is the main important terminology we say about the geographical indication means we can say the in different region somehow about the design of sari, the design of any means the design of any cloth, right? Different in different regions means in Tamil Nadu there is a different way of design or a pattern or means use the fabrics like fabrics also use also different colors to make the designs, right? So these all are comes also in food also, all are comes the geographical indication of goods, because you made or create or a something you can through agriculture pattern, you grow a new type of fruits to according to different plants, right? These all comes are in the geographical indication, that's called GI. The registration and the protection act comes in the year 1999, right? And the Department of Education covers the Copyright Act, that is the 1957 in the year and amended in 1999. Somehow this slide shows our controller of general of patents, design, trademark, the patent office, the registry, the IPTI MIPAM, that is the also in Nagpur, also in the Delhi region also, right? In the GI registry, Chennai only office, and patent office, the head office of the patent only. It was the Kolkata, Delhi, Chennai, and Mumbai, right? Also the NIPAM, this activity at NIPAM office, we can for the design patent. Also, we Nagpur now one of the new branch has established in Delhi also, right? And TM registry office, head office in the Mumbai, Delhi, Kolkata, Chennai, right? And Ahmedabad also. Now, laws and regulation. Patent Act in 1970 amended in 1999. It is the 3 times amended Patent Act in 1999, in the year 2002 and 2005. Patent rules, this is the act and rules, both are the different things, because Patent Act and patent rules come in the, we say which type of patent to be patented, which type of design, which type of means activity, means any physical object, means a product which is suitable for our society. Basically, we connect this patent law and regulation for our society and the ownership also, because I am the owner of any patent. We their funding, their revenue comes across me, because it is my invention or innovation, but we can use this innovation or invention for our society, because we all are connected with the society. Patent rules amended in year of 2005 and 2006. This is the measures of the patent form 1.11/1995. This is the for only, it is comes for the pharmaceutical industry, only for pharmaceutical and agrochemical products, right? And exclusive marketing rights. Also now after that, forms 1 in 2000 for patent it is term increased to 20 years, 10 years to 20 years. Before that, it is the only for 10 years. Now it is increased to 20 years, right? Definition of invention. That's before this slide, I have already quote the difference between the invention and the innovation. This is the inclusion of inventive steps, right? Reversal of burden of proof on the infringer, mandatory compulsory license provision of for food, drug, and chemicals, right? This is the all the removed because from the in the 2000, the license provision, the license provision is removed from the in the year of 2000 because it is not comes in the patent department, because all we know there is the GI formation, design patent, trademark, also licensing departments are different. From that, this is the provision of license to provision for food, drugs, and chemicals, right? Right for patentee importation also included also in this form. After slide we can I can show you, right? And from 1/1/2005, the product patent for food, chemical, and pharmaceutical, right? Then we have meet our international committee also. Somehow these all these forms means 1995, 2000, and 2005. These amendment also the correction going on through the international committee members, because amendment in day by day, in the year by year, is changed. Because if we term call the term of life of patent, it is increased to 10 to 20 years, right? Patent law, there is a silent features, some silent features of patent law, because maximum people or maximum students don't know that both product and process are patent provided, because all know that the product only product patented, but process is also patented, because process is your idea, your imagination, your innovation. You can also do a patent for a process also, right? Any process. Term of the patent means life of patent, the 20 years. Examination on request, if you have need some time to examination purpose, because all patent are show their result, show their all the parameters in near of patent office, in the patent office. That's why you need you prepare, you create own examination on the request. Both pre-grant and post-grant opposition also available in this patent law. Fast track mechanism also available for disposal of appeal also, or also fast track mechanism also available for do the patent application, file and publish their patent in patent portal. In the official patent portal, you can also publish on the fast track mechanism through this law, right? The provision for the production of the biodiversity and the traditional knowledge also. The publication of the applicants after 18 months with facility to early publication, because this early publication are now in 2019 from onwards. It is only you can publish in fast track mechanism for in the 1 month only. In the 1 month only, there the charges is different, because around 53,000 rupees you can pay, and you can if your patent or your any noble work is searched by any division or any office or any official employee, right? Go through the channel, right? And substantially reduce the timelines. You can, because before some years, the patent when you filed, you also get a after 4 years, 5 years, and then 10 years also. But now onwards, you can maximum 3 years, maximum 3 years. Basically, the laws and the act are amendment in the yearly, right? If through the consultant and also the international. We already discussed with the what is the invention. Invention means this is section 0.2. This is already defined in the patent law named section 2 bracket 1 bracket J, right? Invention means a new product or a process involving an incentive step and capable of industrial application. Also, it is also societal application also, because not only for the industrial application, societal application also, right? Patentable subject matter is the invention must relate the process or product of the both, be a novel, involves an inventive steps, be capable of the industrial application or societal application, and not fall under the section 3 and 4. Now we see in go the slides before that, section 3 and 4. Before that, we what is the means of new? What is the new? Invention must not be published in India or elsewhere. If you publish already in an article or in a journal, you cannot publish. You cannot publish, or you cannot apply, or you cannot file as a patent in a patent office, right? In a period public knowledge or public use within India, that is already used in our society, right? Claimed before in any specification in India. This is the must, and this is the new means new thing, which is we also talk about what is the new. What is the new? Okay, right? Because we before we patent any matter, you search their patentability. You search there with any official employee of patent or registered firm of patent. This is the inventive steps, all you know. Now we skip this slide. Section 3, inclusion. Already we discussed here in this slide. You can see not fall under section 3 and section 4. What is this section 3 and section 4? Because invention we create. These sections are, first of all, we discuss this section 3, section 3A. This is the frivolous invention, means insufficient. You can Hindi in say tuch, right? Small. This is the no word comes frivolous invention. You can't patent this invention. You contrary to well establish the natural laws. That is the machine. You can say na machine that gives more than 100% performance. It is not a right sentence, and we cannot say any machine gives 100% performance. Also, the perpetual machine, this can't. This is the exclusion. This is the exclusion from the patent, right? You know about them. Section 3B, the commercial exploration or the primary use of invention, which is cause of serious prejudice to health or human, animal, plant life or to the environment. Because you in your mind, because we go through any invention, first of all, our sustainability process is in one position, first of all. Second one, no any issues related to environment on our human being health, in animal health, in plant life health, right? Examples that biological welfare material or device, weapons or mass destruction, these are not the exclusion of this patent. You can't the patent is the terminator gene technology, embryonic stem cells. These all are exclusion through the patent, right? Now, the section C inclusion, where the discoveries of the scientific principle, you can't patent it, right? Because this is the under section 3 exclusion, like the Newton's law, right? The formulation of an abstract theory, the discovery of anything, living thing, or discovery of non-living thing occurring in the nature, you can't, right? These are the exclusion. Okay. Now the section 3D exclusion, what is the main discovery of the new form of a known substance which does not result in the enhancement of the known efficiency that this substance. All these sections comes across the Indian also, and outside means international also, for US and the China also, because all the sections you can't do any patent, because if you do a patent, the innovation, the novelty, the connect with the society or industry, this is the more important. This is the also, and the most important part, we can't harm any human being or any plant life through my invention, right? This is section 3 inclusion also. Also in chemical industry or for a chemical engineering student, there is the purpose of this clause, the salt, ester, ethers, the polymer, right? These all are not the patentable for this in this section, right? This is the section E, substance obtained by the mere admixture, resulting only in the aggregation of the properties of the component thereof, the process for producing such substance, right? Example, a combi flame, right? Somehow in some years ago, like I think combi flame, a tablets medical issue, already it is a contains a paracetamol, Burfen. This is not a patentable. This is already banned because it is harmful for human being, right? Solution of sugar and the color additives in water to form a soft drink, it is not patentable, right? However, a mixture resulting into the synergistic properties of the mixture of the ingredients, however, may be patentable. Soap, detergent, lubricant may be patentable, right? This is note for all of you. A mixture resulting into the synergistic properties of a mixture of ingredients, however, may be patentable, like soap, detergent, and lubricant. But you can only in water, you can use soft drinks, or simple you can use in any chemicals, right? Sugar or color additives, you can't do the file or a patent in a IPR section, right? Now, this is the check and balance, the effect of this, the substance obtained by mere administration resulting only in the aggregation of the properties of the component thereof, a process of producing such a substance are not patentable, because synergistic formulation, however, synergistic formulation are patentable, but the substance obtained by mere administration resulting only in the aggregation of the properties of the components and thereof a process of the producing such a substance are not patentable. These some points we if your mind, then we do a patent, or any product, any design, any GI issue, means any texture, any color, any logo, any word, you can be patented, right? 3F, section 3F, mere the arrangements of the rearrangement of duplication of known device, each functioning independently of the one of the other is known way, right? A bucket fitted with a torch, an umbrella with fan, right? A clock and radio in a single cabinet, a floor mill provided with sieving. This is the mere arrangement. This is the mere arrangement, right? Or a rearrangement, you can say, right? Or a duplication are not patentable, right? Because some students, some people are doing this work. I am doing some arrangements, I am doing some duplication, rearrangement, and make a new product, right? This is the not a issue. This is the innovation. This is the not invention. This is the innovation. You can't patent them, right? Section 3H, the method of agriculture or horticulture, you can't, right? You can not patent any type of method, any type of for agriculture, for horticulture. It is only for society, for help for society, our farmers, brothers, like, right? Examples for the cultivation of algae, the production of new form of known plant, the preparation of an improved for soil. Improved soil means you get the fertility, and you enhance the fertility of soil and grow any plant. This is not patentable, right? But however, the agriculture equipments, because equipments are a product, or a newly defined invention, can be. That's why we the agriculture equipments are patentable, right? This is the section 3I. This is the exclusion. Any process for medical, surgical, the curative, these all are things. The other treatment of human beings, this is a treatment part, right? Or a similar treatment of animals, of a render them free of disease, to increase their economic value or their products, right? These are the exclusions, right? These are not patentable. You can define a new method to remove a cancer tumor, but you can't patent this. Removal of dental plaque and the caries, the surgical process, the process of relating to therapy, method of vaccination, blood transfusion. These are the example of the section 3I exclusion, right? However, the treatment performed on tissue, right? Tissue culture, heard about the tissue culture of plant also, the tissue culture of human being also, or fluids permanently removed from the body, this are be patentable. Surgical therapies and diagnostic apparatus means instrument. Here also, this is the instrument, because here also the agriculture equipments are patentable. Also here these equipments, these instruments are patentable, because all are mechanical forms, some electrical parts, some means some how IT or CS means their the programming or coding part. You can patent it, right? Section 3 exclusion, also 3J, the plants and animals in whole or any part of their other than microorganism, but including seeds, varieties of the species, and essential biological process of the production or the propagation of plants and animals, right? Section 3J, plants and animals in whole, the parts of plants or animals, seeds, varieties, species, these essential biological processes are not patentable, right? Mathematical method, business method, algorithms, computer programs are not, but combination of hardware and software are patented. New calculating machine are patented. But in computer program, you can say any code, any coding process, new coding process. You can define a result, new code. Then you can apply in a copyright also. Not for patent, not for patent. You can apply in IPR section also, IPR section also, but in copyright section, right? Your copyright in this algorithm, computer coded this program, benefited to student. You can, right? You can this type of coding, this type of computer program, you can do a copyright for each and everything, right? But not patented. Okay, right? 3L, a literary, dramatic, musical or artistic work or any other artistic creation, inclusion, cinematographic work and television products. These are not protected. But copyright you can use in this stuff. What? Copyright. Because in IPR, already we discussed, already we tell you in first slide in the starting to this webinar, the IPR section comes to the different section of this. So number 1, patent. Number 2, design patent. Number 3, copyright. Number 4, trademark. Number 5, trade secrets. Trade secrets. Trade secrets is that, what is a law that requires that the intellectual property to be protected, not publicly disclosed, right? Trade secret is this. Again, a law that requires that the intellectual property to be protected, not publicly disclosed. This is the trade secret, right? You can use copyright for this, right? Section 3M, a mere scheme of rule of method of performing mental act or method of playing game, you can't, right? Like a scheme for learning a language, method for solving a cross puzzle, method of learning a language, method of teaching of learning, right? These are section 3M exclusion, right? Novel apparatus for playing game. Apparatus, here comes the apparatus or any equipment. Repeating this sentence again and again. You can patent any type of equipment, any type of product, you can patent. Because it define, it can explain you, it is connect with industrial or societal issue, right? Novel apparatus for playing game or carrying out a scheme is patentable. And the presentation of information, this is the my presentation, you can use and you can patent it. No, because any manner of method for expressing information, whether by spoken words, visual display, symbol and diagrams, you can't. Diagrams or design come in the design patent, but it is also a unique and novel, right? Information recorded on keys, this is the another thing. Section 3.0, this is the topography on integrated circuits. Example, Marx works, circuit layout. These are the topography work. You can't use. We can't use. 3P invention, which are a traditional knowledge or an aggregation or duplication of known properties of traditionally known component or components. Example, the The knowledge of traditional already in public domain, wood healing property of haldi, right? The property of haldi, this is the traditional knowledge. The property of any means medical or in terms of agriculture part, right? However, any value addition using traditional knowledge leading to a new process or product which is novel with the inventive step and industrial applicability, right? Extraction of this is the neem type of we extract from this, right? Can be patented, because it is the new valuable product for the society or the medical industry. Section 4, invention falling within the section 21 on the Atomic Energy Act 1962 are not patentable, right? Invention relating to compounds of uranium, beryllium, thorium, plutonium, radium, graphite, these are or in the more notified by the central government from time to time, right? This is not the patentable invention, right? Now, stages of the filing to grant of a patent. How can you go different types of states one by one? I can discuss with all of you, right? Obtaining a patent. What can you do? File an application for a patent with one of the patent office based on the titular jurisdiction of the place of the office or residence of the applicant agent, right? And the pay the required fee. Also, you can go through the www.ipindia.nic.in. You follow the guidelines and file an application, right? Formality check, because it is the patentability check. First of all, you can do through own, but you can go through an official or a any firm, registered firm. To the formality check means this is the check of your patent or any your design, your product, which is patentable or not, right? Publication is the process. Application is kept secret for the period of the 18 months from the date of filing. In 19-month application published in the official journal. But now it is secret only. 18 months of secret you can, right? This is the application kept secret of a period of 18 months. But your application published within a month, right? In 19 month, the application is published in the official journal. This journal is made available on the website weekly, right? The application has an option to get this application published before 18 months also. This is called the fast track publication. Fast track publication within a month, right? In that case, application is published within a month of a request, right? This charge different, okay? 18 months of charge different and 1 month charge is different. And the fee of this fast publication mechanism, right? Request for examination, then after the publishing this or filing a patent, we go for the request for examination. Application is examined on request. Request for examination can be made by either by the applicant or by the third party. A period of 48 months from the date of the filing is available for making request for examination, right? This is the clear about of all of you. Next, examination. After the request examination, you go for the examination process. Application is sent to the examiner within 1 month from the date or request for examination. Examiner undertakes the examination with respect to whether the claimed invention is not prohibited for the grant of patent, whether the invention meets the criteria of the patentability, right? Now, the issues of FER. In some cases, we file a FER or when you file a copyright process, the period of 1 to 3 months is available to the examiner to submit the report to the controller. 1 month's time is available to the controller to vet the examiner's report. First examination report, that is the FER. First examination report containing the gist of the objections is issued within the 6th month from the date of filing of the request. After that, response of the applicants, means you can respond, because here the the controlling officer, right, send you any report, then any response from the applicant. 12 months time from the date of the issue FER is available to applicant to the meet the objection, any objection created by the controller, If the objections are met, grant of patent is approved by the controller within a period of month, right? Pre-grant opposition also, but this is not an issue, because if you go through the firm, registered firm, these all are controlled by the firm's head, right? After the publication, an opposition can be filed within a period of 6 months. Opportunity of hearing the opponents is also available, right? Examination of pre-grant opposition also, but this is the different things. You can't go, but you kept in mind, this is the opposition pre-grant also available in the portal also. A period of 3 months is allowed for the receipt of the response. Only 3 months, right? Grant of a patent is certificate of patent issued within the 7 days, right? 7 days. If any patent granted from this date, you get the certificate in between within 7 days. Grant of patent is published in the official journal also, and you also get a certificate. This is the stage. One of the I show you one designing. This is the flow diagram to understand through different channels. We go through filing of application to complete, then publication, request for examination, examination issue any FER. If any issue comes through the controller, then we resolve this issue. You can answer this the queries, right? These all are gives the time for 18 months, 48 months, third party representation also, right? And the grant of the patent. And opposition you can say within the 12 months, right? But after the grant, I think no one can go the opposition or something in a very minimum in percentage. Anyone go to the opposition or in third party also, right? Renewal fee also, because after 20 years, you must do yours patented the product renewal, right? After the 20 years, because to be the paid within the 3 to 6 months from the date of the recording of the register, section 142(4). No fee for first and second year. Renewal fee only on the basis of yearly. It is required to be paid to the 3rd to the 20th for keeping the patent in force. Delay up to the 6 months from due date, the permissible on payment of fee for the extension of time. Patent lapses if renewal fee is not paid, because if lapses, if you can claim any revenue generation, then you can't, right? That's why if any revenue generation product or any patent, you must renew your patent after the third, means between the last 20 years, in the 20 years, right? In the 20th year of 3rd month, okay? Now, the 2 goals of today's US patent system. First one, simulate the invention. The property right are the somehow you can protect, you can help the ensure the creation, your productivity, means your generation, your creation, and share the knowledge. They promote the progress and the general welfare by disclosing invention, right? How did the US create a patent system for everyone? 6 unique feature. Okay, in US, or you can international, so right. Simple application procedure, disclose the new technology, low fee examination system, no working requirements, and new technology marketplace you have in the US, right? Now, some comparison chart I have made here, the slides, some points I have defined between the Indian patent law and international patent law, right? The major difference between the law in the two countries arises from the way the laws are stated. In US takes a more illustrative approach where it states what can be patented, right? What can be patented. India's patent law, on the other hand, state what cannot be patented, right? This is the main basic logic difference between the India and the international patent law, right? The patent law doesn't allow any minor changes or extensions to patent that already granted, right? The US patent law, however, the grant this flexibility. The US patent law, right? These 3 points are the basic and the important points which differentiate the laws of different nations. And the third one, in the US, there's something called the utility patent. This allows the patenting of a discovery or a process or a machine, provided the discovery is novel, useful, or unobvious. This isn't the case in India. India's patent law do not allow you patent the mere discovery of the process, machine, or product. Mere. But in US, you can. Right? Because noble, useful, and unobvious. Because in India, unobvious product or patent, not allowed. Right? In this India's country, nation, right? But in US, you can. Unobvious issues also. Noble, useful, and unobvious. These 3 points are very important points. Rest, all other things are equal, because we file a patent and then we grant a patent. The process almost same, because this is the different nation. There's the rules and regulation. You can, there's a section, all these section A to section NO, right? Different in India. But somehow, in some cases, only the unobvious product, unobviousness of any novelty, unobviousness of any innovation, invention, right? Not allowed in India, right? It is all about my side. If any questions, if any queries about student, please you can ask me.